Capacity means the person who is competent enough to enter into a contract. He should be the age of, that is, he should attain the age of majority. That means above 18 years. The court will appoint a person called as a guardian. The guardian may be the parents or some of his relations, right? So an agreement with a minor, therefore, can be never enforced. Hi and a warm welcome to all dear students. Hi George William A, Commerce Faculty, Vidhyaashram First Grade College, MYSURU, a Temple of Excellence. Welcome you all for Session 1 of Unit 2. Dear students, today I am going to start the chapter or the Unit 2 of Business Laws. In that, we will be starting with the Session 1. Before going to Session 1, let us have a glimpse of the previous chapter or the unit which I explained to you or covered, where I explained about the contract, then what is agreement, the definition of contract, right? Then what do you mean by offer? What do you mean by acceptance? What are the legal validity for offer? And what are the legal aspects for the acceptance or the valid acceptance? And what are the termination for an offer? So like this, each and every topic I had explained to you in the previous unit, and I finished that particular unit. Now in today's session, we are going to speak about, or we are going to discuss about this particular topic that is known as the capacities of parties and various other contents. Now students, let us understand the meaning of capacity to contract. What do you mean by capacity? Capacity means the person who is competent enough to enter into a contract. So a person who is competent enough to enter into a contract. So those persons who are competent enough and those are in capacity to enter into a valid contract, they are called as the capacity to contract, or we call them as, we say that the contractual capacity. That means the person who is having the capacity or who is having that capacity or the competence, we say capacity or the competence to enter into valid agreement, then that we call it as the capacity of parties or the competence of parties. So capacity or competence is nothing but in a contract. Now, to a contract, there are two persons. When you enter into a contract, there will be two persons or two parties. Both the parties who are entering into a contract, they should be of having the capacity to enter into a contract, or they should be competent enough to enter into a contract. That is what it says according to law. So that legal capacity should be there. Only when there is a legal capacity among the partners or by the parties, only those can be entered into a legal agreement or a contract. Now, in other words, we can see the capacity of the parties, that is to enter into a legal contract. So only those persons who are having that capacity, who's having that capacity as well as the competent enough, only those can enter into a valid contract. That is, which has been binded by law. Only which has been binded by law or according to law, those who are said that they are competent enough and they are competent and having capacity, only those can enter into this particular contract. Now coming to this particular topic, it says, as I told you, only the persons who are competent enough and having the capacity to enter into a contract. Now the question arises, who are the competent to enter into a contract? Who are competent to enter into this particular contract? So who are those? It says every person, any person who is legally accepted, right? Who is legally having that capacity or who is competent enough, they can enter into the contract with the following terms and conditions, such as he should attain the age of maturity. That is, the person who wants to enter into a valid contract, then he should be the age of, that is, he should attain the age of majority. That means above 18 years. So that person who is above 18 years can enter into a valid contract. So he is having that capacity or he is having that competence to enter into a contract only who is having, that is, the age of 18 years and above. Second, he should be of sound mind. What is a sound mind? Sound mind means that when you enter into contract, both the persons or any person, both the parties, they should be of having sound mind. That means they should be well aware of what kind of contract they are entering it. They should be able to understand that particular contract, and they should be having the same sense and knowledge at the time of contract. So they should be a sound-minded person. The unsound mind person cannot enter into a contract, such as it may be the lunacy or it may be the idiot, right? The person who cannot understand, what the term contract is not in a good mental position, right? Or he may be bankruptcy, like this. There are so many things where we discuss this in the later stage. So those persons cannot be entered into this particular contract. So here it says he should be of sound mind. Only a sound-minded persons can enter into a contract. Thirdly, it says he or she should not be disqualified. He or she should not be disqualified by contracting into any of the other law which is subject to the subject matter. So according to Indian Contract Act, it says no, those persons who have been contracted and it's been disqualified by the law, those persons cannot be entered, or they cannot enter into a contract or agreement between the parties, or they cannot make any kind of contract, right? So again, I'll repeat. It says who are the competent to enter into contracts. That is, first one is that he or she should be attained the age of 18 years and above. That is, should be age of majority. Second is he should be of sound mind. And third one is he or she should not be disqualified from contracting of laws or to the subject matter of that particular contract. Now coming to the minors. Who is a minor? A minor is a person who has not attained the age of 18 years, right? So he is called as a minor. So a person who has not attained the age of 18 years, which is prescribed by the law, according to Indian law, so those persons are called as the minors. And Section 3 of Indian Majority Act prescribes what it prescribes, that is the age limit for majority, and says the minor is a person who has not completed the 18 years. That's what, according to this particular Indian Majority Act, also prescribes that who is a majority person or who is a minor and who is a major. Who is a minor? The minor is a person who has not attained the age of 18 years, who is below 18 years. And who is a major? The person who has attained the age of 18 years and above, right? That is complete 18 years of age is called as a major. Now, but in some cases, in some of the act, it also mentions that the following two cases, there are two cases where the person who attains the age of majority, right? Majority only after he completes his age of 20 years only. So in some acts, they have said that there are two important cases where they said that even at the age of 20 years, that is, even he has attained the age of 18 years, he cannot enter into a contract. That means he should have attained or complete the age of 20 years only, or 21 years. So he should be completing 21 years, then only he is able to or enter into a contract, or he is having capacity to enter into a contract. Which are those two acts or the cases? It says when the court has appointed a guardian. When the court has appointed a guardian. Who is a guardian? That is a minor. He cannot do all the things on his own. So the court will appoint a person called as a guardian. The guardian may be the parents or some of his relations, right? So when the court appoints a guardian of a minor person, then, or a property or both. So it says when the person, that is when the court appoints a person for the minor, that is on looking after the properties of a minor, or looking after the whatever the properties or any other things which is there, which is coming under minor. So the court will appoint a guardian, and it says under Guardians and Wards Act 1989. That is, so under the Guardians and Wards Act of 1890. So according to this act, the court will appoint the person to look after the minor's property and all his assets. And here secondly it says when the minor's property has not been placed, right, under the superintendence of the court of wards. So under the superintendence of court of wards, if the minor's property is not been placed, so then in that case also he cannot enter into contract even after 18 years. Only after 21 years, in this case, he can enter into a contract. He can be called as the major person or a majority. He attains a majority. So second is, who are the persons of unsound mind? Who are the persons? Who will be called as the persons of unsound mind? As persons of unsound mind, it can be like only a person who is having a sound mind, only those person can enter into contract, right? So as you know that only the person who has attained the age of 18 years, then, or in that cases, in some cases I told you in 2 cases, where he has attained the age of 21 years, then he can be a party. He can be a party to the contract, or he can be enter into a contract. But here, the persons of unsound mind means the person should be clear from unsound mind. He should be having sound mind, and only those can enter into a contract, or they can come into a contract. So only those persons are capable, and is capable of understanding the contract time of making it. So the sound-minded persons only will be applicable, or they'll be eligible, or they'll be having capacity or competent to enter into contract. And at the time of entering contract, that person should be understandable. Whatever the agreement or the contract is been made, that should be understandable by this particular party. That means only the person who is having sound mind can do this, right? And is capable of making a rational judgment, right? So this person who is having a sound mind, only those person can be taking a decision, good decision regarding the contract or the agreement which he makes, and that will have an effect on his interest. So whatever the judgments or decisions he takes at the time of entering contract, that will have a greater effect at the later stage in this interest, that is in the subject matter of that particular contract. So a sound person, I'll repeat, a person is said to be a sound mind for the purpose of making it a contract, right? As well as he should be capable of understanding the contract. He should be capable of understanding the contract, and whatever the terms and agreements or conditions are made, so during the time of contract, then he should be able to understand it, right? That is possible only when he is having a sound mind. Then at the time of entering into contract, and also they say that capable of making the decision or the judgments for the subject matter of that particular agreement or the contract. So this is possible only with the sound mind person, Now here you can see who are the persons of unsound mind. Who will be called as an unsound mind persons? First one, as I told you in the beginning itself, unsound mind person can be an idiot. Means he doesn't understand whatever we say or whatever we do, and he doesn't understand anything. That's why we say he's an idiot. Then lunatic, right? Is not capable of understanding. Then delirious persons. Then drunken. If a person is drunk and if you ask him to enter in contract, then at time of contract, he will not understand what he is writing, what he is signing, and he will not understand each and anything of it, right? Of that particular contract. Each and anything of that particular contract. So drunken person also cannot be a sound-minded person, and he cannot enter into a contract. Then hypnotized person. Who are the hypnotized person? One who has been hypnotized and who is not in a clear mind, right? Those person also cannot be entered into a valid contract. He is not having that contractual capacity to enter as a partner to the contract. Then mental decay. That means he is totally out of order. So he is totally, we say mental. Mental means he is not having that capacity to understand anything, right? So those person also cannot be entered into a valid contract, and they are not capable or not eligible to enter into a contract. Now here, which are the persons who have been disqualified by the other laws, right? So there are certain persons. Here there are certain persons who have been disqualified by the other laws, who cannot enter into a contract. So such as it says, and according to a law of country, so these are the persons who are not eligible, who is not having that capacity or who is not having that competence to enter into a contract as a contract person, right? Or as a party to the contract, such as an alien enemy, means somebody from outside, from other country, right? Or he is from other world, who is an enemy. He cannot be a person to enter into a valid contract. Then foreign servants and diplomatic staff. So the persons who are foreign, who's in the rank of ambassadors of different countries, right? Or diplomatic staff means that's what, who are in the embassies, right? Those cannot be entered into this valid contract. Then corporations and companies, the persons who are in the corporation or the main big corporations as well as the companies, they cannot be entering into a contract. Then insolvents. Who are insolvents? The persons who is not having a solvent mind. So that person cannot be a party to the contract. And convicts, that is the thieves, robbers or dacoits or terrorists. So those have been convicted by the law of country. So those persons also cannot be a party to the contract, or they cannot enter into a contract. So these are the persons who have been disqualified according to the law of country, right? First one is the alien enemy, second is foreign servants or diplomatic staff, then corporations and companies, then we have insolvents and convicts. Now coming to the nature of minus agreement. What are the nature regarding minus agreement? If the minor has entered into a contract, then what are his agreements according to it? First is void ab initio. Void ab initio means it says the minor agreement is absolutely, totally, minus agreement is totally void. That means it cannot be a contract. It cannot be a contract. So it is absolutely void, right? Totally void. And from every beginning, that is void ab initio. It means there is nullity. There is nullity in the eyes of law. So in the eyes of law, if a minor has entered into an agreement, that agreement cannot be a valid agreement. It is a void agreement or void contract. So minor enters into a contract as a party, then that particular contract, according to the eyes of law, it is a nullity or it is a void contract. So an agreement with a minor, therefore, can be never enforced. Therefore, we say minor cannot be entering into a contract. He cannot be a party to the contract. So he cannot be enforced by law. He cannot be entered into the contract according to the law. Secondly, it says minor can be a promise or beneficiary. The minor, he can be a promisee or beneficiary. That means he can get some benefit out of this particular contract. So minor can enforce such kind of agreements in which he is a beneficiary. So he can enforce some agreements between the parties where he can get benefit out of it. So where he will be the beneficiary or the promise, and he says it does not create any obligation on his part. So there is no obligation on his part, but he can be a beneficiary for this particular contract, or he can be a promise. There is no ratification. So here the fact that is the nature of minus agreement says no ratification. What do you mean by no ratification? That means the minor cannot be ratified even after attaining the age of majority. Even at the age of majority, even if he has attained the age of majority, then he cannot become a party to the contract, right? Because the void agreement cannot be ratified. It cannot be changed. The minor cannot be ratified. He cannot be ratified even. That means he cannot convict. That means he cannot convert himself. He cannot convert himself as a full-fledged person or a full-fledged party to the contract, because even after attaining the age of majority, right? Because once the void agreements are there, it cannot be converted into a lawful agreement or the contract. Then reconstitution and compensation possible. So here, if a minor has received some compensation, so under this point it says if a minor has received some benefits or compensation under any agreement or the contract, then that is from the other party. So if a minor has received any kind of benefit, right, from the other party at the time of agreement, then the court can require the minor, that is the court may require the minor to restore the benefit. That means to give back the benefit whatever he has got from this particular agreement till now, right, to the other party at the time of rescission of an agreement. That means at the end of that particular agreement, the minor has to give back all the whatever benefit he has received from the other party, he has to return it back to the other party at the time of rescission of an agreement. So a minor can be asked to restore. That means the minor can be asked by the court to restore whatever the benefits he has received. Right? That is, to the extent or his estate has been benefited, to whichever extent he has been benefited by that particular contract or agreement, then the court can ask him to restore it and give it back to the other party at the time of rescission of an agreement. So this is about restitution or compensation possible. The next nature of minor agreements is contract by parent, guardian or manager. So it may be the minor's parent or it may be a guardian or a manager. They can enter into a contract on behalf of the minor. A guardian can enter into a contract, or the parents, contract by parent means the minor's parents also can enter into a contract. They can make a contract. Then the manager of the minors, who is an agent acting as an agent, he also can enter into a contract, right? And that is on behalf of minor. So they can enter a contract, all this person only, that is on behalf of that particular minor. So on behalf of minor, these persons, that is, it may be the parent or it may be the guardian or the manager, right? They can enter into contract on behalf of the minor, right? So here, the parent, the guardian, and manager acts within the scope of authority, even though they are the parties to the contract on behalf of minor, but they have some limitations. So according to the limitations only, they need to do the contract. So they have to be within that particular limitations and the scope, right? So they cannot go beyond it. Then the contract is for the benefit of the minor. Whatever the contract they are entering it, that should be for the benefit of the minor only and not for themselves. So any contract which is been entered by the minor's parents or the guardian or the manager or an agent, then those kind of contract should be benefited to the minor and not for the parties who are entering on behalf of a minor. Then there is no liability of parents here. So it says the parents or guardian of a minor, they are not liable for agreements. These people are not liable for any kind of agreement made by their minor ward. So if minor has made some agreement, then these persons they are not liable for that, right? But however, they can be liable if the minor makes agreement as they are authorized. But in some cases, the minor, what he does, he may be doing or authorizing to enter into a contract or to make an agreement. In that case, he will be held liable. That means they can be, that is the parents or the managers or the agent or the manager of that particular minor who is entering contract on behalf of the minor, they can be held liable in case, that is, if a minor makes an agreement, in case if the minor makes an agreement as they are authorized. Means I authorize that particular person to do something. So in that case, they will be held liable. Next is minor and insolvency. What is this minor insolvency? It says a minor cannot be declared as an insolvent because he is not competent to the contract. Only a person who is a major and who has attained the age of 18 years and entered in contract, only those person can be and who is incompetent, right? Or who is incompetent as well as insolvent, then you can call them as an incompetent or insolvent. So here the minor cannot be declared insolvent because he is not competent to the contract. He is not having the capacity or he is not competent, he is not eligible to enter into contract. In that case, you cannot call the minor as an insolvent person. Insolvent means who is not of sound mind, right? Next is minor as a joint promisor. So minor here, in this case, he will be acting as a joint promisor for a contract or agreement. So minor can be a joint promisor with the major. So the person who is a major and this minor, he can act or he can join with that particular major and he can be a joint promisor. He can be a joint promisor in the agreement or a contract. but the minor cannot be held liable. So in this case also, even though he is having a joint venture or a joint promisor, even then he cannot be held liable for what? That is, under the promise to the promisors as well as to his co-promisor. He cannot be held liable for any of the acts or any of the things happening in the contract or the agreement. He can be just taken as a joint promisor, but he cannot be held as a held liable for any of the acts or any of the things happening in the contract between the promises or the promises or the promisees. But the major promise cannot escape liability. So whatever the major promise he makes as a joint promisor with the major, in that case he cannot escape from that particular liability. So here the major joint promisor, what he says, can be enforced to perform the promise. So major joint promisor, so he can ask the minor to perform whatever the promise he has made when he has entered into contract with the major. The last one is the minor's shareholder. What do you mean by minor's shareholder? A minor can become a shareholder or member of a company. So any minor, if he wants to become a shareholder or a member of that particular company, so minor can also become a shareholder, or also he says he can become a member of the company where it says if the shares are fully paid up. Only in case when the shares are being fully paid up by the shareholders, then he can become a shareholder or a member of the company. Then if the articles of association do not prohibit so in the article of association, there should not be any kind of restriction or the prohibition that is on entering into a contract, that is making the minor as a shareholder. In these cases, he can become the shareholder of the company or enter into a company. Now, next is the liability for necessity of life. So, under this case, a minor is incompetent. As you all know that, he is an incompetent to contract because he has not attained the age of 18 years. In that case, he cannot be competent to that particular contract. A minor is therefore not personally liable for any of the payment. So, in this case, when he is not competent enough to enter into contract, then you cannot held him liable. You cannot held him liable for all the personal liabilities, right? That is for the payments of the price of necessaries of life supplied, whatever the necessaries which is being supplied on to him or to his legal dependents. So you cannot ask anything from him. You cannot ask anything from the minor because he is not competent to the contract. He is an incompetent person to a contract where he is not liable. So, however, the person who has furnished such supplies is entitled to be reimbursed from the property of the minor. But whatever it says, however, the person who has furnished the supplies, that is, which is entitled, which is been entitled to reimburse, that means to get back what he has supplied. So that can be done from the property of the minor. So from the property of the minor, if they have supplied something to the other person, then in that case, whatever the reimbursement has to be done, that can be done from the property of the minor. And the next is, according to Partnership Act of 1932, it says a minor cannot make a contract. According to Indian Partnership Act of 1932, it says a minor cannot make a contract of partnership, right? Why? Because though he may be admitted to benefits with the consent of all partners, even though to get the benefits from the partnership and with the consent of all the partners in the partnership firm, he can be made as a beneficiary, but he cannot be a partner in the partnership firm. So a minor partner cannot be made personally liable. In this case, the minor cannot be made liable for any of the acts or if any of the losses at the time in the partnership which takes place, right? For any obligation of the firm. But his share in the firm's property can be made liable. But his share of firm's property, here it says can be made liable. So in that case, if anything loss occurs, then he is liable for that particular loss and he will be liable from the property or for the property of the particular firm. Then no estoppels against minor. This is also one of the nature of the minors agreement. It says the term estoppel. What do you mean by term estoppel? It means prevention of a claim. That means you are preventing yourself to be claiming that as such that you are so and so. So you are abstaining or you are preventing yourself and saying that no, I am not that. So when a minor enters into a contract, right, representing that he is a major. So he is entering contract and saying that I am a major. So here what happens? He is not. Then later stage, that is that he is a major, but in reality he is not. Then later he can be plead his minority as a defense and can be stopped, prevent from doing so. So at the time of entering contract, what happens here according to this particular estoppel nature? So here the minor enters into a contract, fine, but how he is entering? That is, he is representing him as a major. That means he is already attained the age of 18 years. Saying this, is entering into a contract. Okay, but he is in reality what it is, he is not a major. So in the later stage, what he can do is he can plead. He can plead that he is a minor, and whatever he can defend himself, and he can be stopped, means preventing from doing so in the next future. That is, in the coming future, he can prevent himself from doing so. These are the various topics regarding this particular session. So I had explained to you about, that is, capacities of parties, the meaning of capacity or to the contract. Then who are the persons who are able to enter into a contract, that is, who is competent enough to enter into a contract. There I told you that the person who has attained the age of 18 years, as well as the person of sound mind, as well as the person who is not disqualified or contracting of laws, can be entering into a contract as a party. Then who is a minor, right, and what are his natures, and who are the unsound mind persons, right? So here I told you the unsound mind persons are idiot, lunatic, delirious persons, drunken, hypnotized, and mental decay. And here you can see which are the persons who have been disqualified by the country of law, such as it may be the alien enemy, then we have foreign sovereignists, then diplomatic staff, then corporation companies, insolvents, and convicts. And these are the nature of the minors agreement, that is wide ab initio. Then minor can be a promisee or a beneficiary, then there cannot be ratification, then compensation is possible for the minor, then contract by the parent or the guardian, they can enter into contract on behalf of the minor. Then no liability of the parents cannot be taken into consideration, or they cannot be made as liable or held liable. Then the minor cannot be called as an insolvency or insolvent person. Then minor can act as a joint promisor with the major, right? Then he can be a shareholder. The minor can be a shareholder, as well as the liability for necessities of life. So anything he has undertaken for the necessity of life, then he is held liable for that, and from the property of the minor, they can be reimbursed. Then the minor party, who was a minor partner, so only those persons being a minor partner in the partnership, he cannot enter in partnership firm, but he can get the benefits from the partnership with the consent of all other partners. And here he can prevent himself from doing so, or he can defend himself from doing so. That is what he has done, that in reality he is not a major, but he has said lies that he is a major. Being a minor, he has entered into a contract, and later on when they come to know about that fact, then he can defend himself, saying that without my knowledge I have said this, something like that. He can say it, and he can prevent from or defend himself from doing so. So these are the various topics I had covered to you, dear students, in this unit 2 of business law in session 1. So hope you have understood the topics. So thinking that I am going to leave this session. So I'll see you all in the next session. Until then, have a nice day. Take care. Thank you, students.